and handed over to the father. Your Lordship would have the impugn order at page number 66. And prior to that, taking to the impugn order, Your Lordship, may I request the Honorable Court to have page number 33, by which the learned court below has granted the custody to the father. May I request Your Lordship to have page number 33?
Just
Am I with my lords?
are you in a hurry?
No, my lords.
Yes.
It's
Page
the order,
number?
page 33, Your Lordship. This is the order passed below Exhibit 60 in the family suit 2582 of 2000, which is the divorce proceedings filed by the husband. May I permit it to read this order? It's a short order. I will pick only this. Para 2 is of relevance, which I am pointing out to be taken into consideration. The petitioner father has filed the application to restore the custody of the two children, Kevin and Dhanil, on the ground that the respondent mother has been given the interim custody of the children by way of a compromise dated 14/6/2020. But thereafter, the respondent mother has not returned the custody of the children to the petitioner and thereby committed a breach of contract. The respondent mother has objected this application by filing a reply at Exhibit 17 inter alia, declaring that the children are not ready to go with the petitioner father, and she has not forcefully retained the custody of the children. The respondent mother has contended this application is not maintainable and law because the petitioner is required to file a separate application under the Guardians and Wards Act, and the present petition for divorce proceeding cannot claim the custody of a minor children. After having heard the learned advocate for the parties and after having perused the record of the proceeding, admittedly the custody of the both children are with the petitioner father. Wherein the present petitions are filed during the pendency of this petition, the petitioner had given a temporary custody of both the children to the respondent by way of compromise, as stated in the portion of Exhibit 30. The respondent thereafter backed out from the compromise and not handed over the custody of the children to the petitioner. The petitioner is the father of the children when the petitioner was filed. Admittedly, the custody of the children was with the petitioner father. The interim custody of the children were given to the respondent mother by way of the compromise. Under the circumstances of the custody, the children is required to be returned back to the petitioner father in the interest of justice. The contention raised by the respondent that the petition is required separate
This
application.
order was not challenged by you?
But this was not challenged, and we are in process of challenging this too. We are awaiting the certified copy. As soon as we got a first certificate, I will be very candid to the honorable.
In which year you will challenge?
We will be challenging the questions. And Your Lordship, we have preferred an application for transfer. Petitioner as a government employee working in a food and drug department as a scientific officer. We preferred a petition before this honorable court transferring the divorce proceedings before the coordinate bench of this honorable court, which the honorable court was pleased to allow the petition. Now, Your Lordship may kindly see para 2 of this order, my lords, wherein the petitioner has categorically requested before the honorable court, and I have made an averment.
Where is your application?
My application.
Below Exhibit 5 where order is passed.
My lords. That Your Lordship would find at page C. This is my custody application, and
Page number?
in a minute. Page 52. So, before I take my lords to this application,
Where is your main application?
main application is page 38, my lords. Yes, we have also prepared an application under section 9, my lords, wherein a notice has been issued, and we have said that we are willing to forget and let go everything, my lords. Our mother is deprived of the children, my lords, and therefore the visitation rights are being granted. But my lords, it's the fate of a 4-year child, my lords, which is
Section 9 is filed when?
yes, by me, my lords.
When?
It has been filed, my
For
lords.
this order?
Prior
After
to that,
the
my lords.
impugn order?
After that, my lords.
After the impugn order?
After the impugn order. It's filed on on 12/4/2024.
Divorce proceedings are initiated by?
Divorce proceedings are initiated by the husband, my lords. They are right now transferred to Vadodara because the wife is a government servant who is working there. Now, the only request to the honorable court is that the child who has shown his consent to go go with the mother before the concerned judge, my lord. So the honorable judge has awaited the request of the wish of the child, my lord. This is one of the ground of which I have raised before this honorable
What
court.
is the finding?
The findings are in the exhibit 5. Your lordship would see. Yes, sir.
Para 7.
Para 7. I'm obliged to balance. Page 16. Looking to the above factual legal aspect, and it is important to consider the aspect that the application for visitation right that the petitioner has, as stated above, a biological mother of a minor child, and therefore, according to the ratio laid down by the Honorable Supreme Court judgment, which has been rendered on 13th November 2010, in case of Dr. Ashish Ranjan versus Dr. Anupama Tandon in contempt application, civil application, transfer petition, it is reported in 2010, 8 Supreme Court 162, reported in so-and-so in paragraph 21. It is necessary for the child that he should be regularly contact with non-custodial parent also. Here, at the present, there is no question to remove the minor children from the custody of the respondent. Moreover, this court also feels that the mother might have love and affection toward the children, and she might have desire to meet the children also. On the other hand, the children should also not be deprived of getting love and affection from the mother during the childhood, that should not become the victim of the disputes between their parents. At the same time, they should also not be used as a tool in the parents' battle. The children cannot be treated as a property.
There is the observation that the children do not want to go with the father.
That has not been recorded. In my respectful, I have made a specific contention which your lordship would find at page number 9 of my memo, the petition.
No, in the application, find out.
But that
is there
not,
any averment?
I will be. It's not there. There is no averment. It has not been put. And secondly, your lordship may consider there are chances of settlement between the parties. And the command of the children is there much. The child is just of 4 years old. I know the paramount consideration is there. The judgments I have placed before this court, and I'm conscious your lordship would have utmost consideration on this aspect. If a notice has been issued in this matter, something can be worked out. I will be candid to the honorable court on this regard. I am not arguing for the sake of arguments. I am very conscious of my limitations also.
This order is passed on in the month of December.
Yes.
23.
Yes.
Till date, what is the status?
The mother is regularly going
and meeting the children.
Meeting the children. And she is a government employee, so some Saturdays are working Saturdays. Even your lordship may kindly consider my prayer. I am not throughout asking for the whole custody, but I know I have a right over that because of the statutory provisionals. But I am seeking the kind indulgence.
Why all of a sudden you are challenging this order?
That's the mother is on a very, very bad condition. I will tell it very honestly. Sir, 4 years kid.
No. The order of December is challenged.
I know it.
Why? What
Sir,
is?
it takes time. Your lordship is well aware for a litigant to approach. If we go into legality, it will be very difficult in such
All
case.
of a sudden, you found that this order is bad.
I will tell honestly, it's not something which is advised by an advocate. It is something which is coming from the mother's heart to appeal this honorable court to give some consideration.
Development must have taken place. Therefore, she must have realized to challenge this order.
So this is my appeal to you, your lordships, that it may be considered in a utmost interest of the child. Some extension of visitation right or a custody can do. It's a 4 years. Even the statute does not permit. If your lordship feels their lordship may call upon the children and ask their consent. A mother is requesting the honorable court. Law is there, my lord. So I do not want to take my lords onto the judgments which are there of the Supreme Court, that once there is a consent, it has to be. So I have placed everything on the
children are meeting mother on Saturdays.
On Saturdays.
How was the meeting?
Meeting is going very well. But the father is not even allowing to even speak on a phone, sir, except the days on which the court is there, minutes. She is willing to let go everything in past months. Forgetting the past months, she is willing to go back to his children needs.
Let's see. Notice.
Grateful. Grateful.
26.
Grateful.